My name is Min Kim. I'm a partner and immigration attorney here at the Edison, New Jersey office. I see that folks are starting to join. So in the interest of time, we'll get started with. Thank you for showing interest in attending. I try to provide a different array of topics. Knowing that some people might come from different points of view in terms of their level of experience for immigration. We're going to be talking about NIV, non-immigrant visa, classification updates, as well as for green cards as well. A lot of it's obviously going to be focused on employer-sponsored business immigration. Just kind of provide an overview of H1b cap season, the changes that were in effect as a result of USCIS kind of revamping their lottery selection process, making everything online and electronic, and changing the order for the master's cap exemption selection as opposed to the regular lottery. So we'll begin by talking about individuals and companies that are exempt from the H1b cap season, as you can see depicted in the slide here. Specifically the Immigration and Nationality Act, as folks know, that's the statute that I suppose is the Bible of some sorts in terms of immigration law. It exempts certain employers and individuals from the annual cap placed on H1b visas. Individuals include who are exempt from the cap, who have already been counted against the cap, and certain beneficiaries who are eligible for certain waivers. Certain employers are also exempt from the general cap, and those organizations include institutions of higher education, nonprofit entities related to or affiliated with an institution of higher education, nonprofit research organizations, and government research organizations, as described in the slide here. So we'll do a quick deep dive in terms of the different categories for individuals who are exempt from the H1b cap. So starting with employee-centered H1b cap exemptions. So obviously the most common employee-centered exemption involves individuals who are filing for an extension or transfer of their H1b visa status. So a beneficiary who was previously counted against the cap, or perhaps an amendment petition for which an extension of the visa validity period is not requested. So just basically filing an amendment without a concurrent request for an extension of H1b status. A beneficiary might also be exempt from the cap if he was counted against the cap before through the sponsorship of another employer in the 6 years preceding the filing of the current petition, unless that individual would be eligible for a full 6 years by spending 1 year outside the United States. And I suppose here, I can perhaps take a step back because if an individual, an H1b beneficiary, is exempt from the H1b cap, if he or she never entered the United States under a previously approved H1b petition, kind of assuming the fact that a previous H1b sponsoring employer never submitted a request for withdrawal of the earlier approved H1b petition. So I suppose, meaning that is someone counted against the cap if they never activated their H1b visa and entered the US and sought admission. And I suppose, just from my standpoint, I suppose a conservative view of that is, those individuals should still be considered not counted against the H1b cap, and therefore they are cap subject because they never activated their H1b visa. They were never admitted into the U.S. in the first place, so therefore a change of employer transfer petition cannot immediately be filed. A pay stub, a pay period would have to run in order for that transfer petition to be filed and for that person to start based upon portability. Even though the law might support that interpretation, in practice, USCIS has really relaxed that requirement, and they've seen a string of approvals where those foreign nationals who might kind of fit into that, in that criteria, who never activated their H1B and never really assumed H1B status effective October 1st, a transfer petition can still be filed for those individuals, and USCIS continuing to accept those change of employer transfer petitions, despite the fact that an individual never really activated his or her H1B visa yet. So, just continuing to move forward, I suppose, I did want to include the comment that individuals who are here pursuant to a J1, they're also likewise not subject to the cap, provided that they kind of fit within the the J1 for physicians. In the interest of time, I do want to just kind of go through these points rather quickly. When it comes to the employer centered cap exemptions, as I referenced, there's certain categories involved for institutions of higher education, GROs and nonprofit organizations, and there are a list of criteria in defining, what constitutes a government research organization and what constitutes a nonprofit organization as well. I suppose an interesting thing here, and this is a change, as some might know, from the skilled worker rule that took effect in 2017. The skilled worker rule, I suppose what happened was, for individuals who are not sponsored by, let's say a cap exempt organization such as a university or a hospital, a nonprofit organization, those individuals can still be considered cap exempt as long as they're employed at those institutions. So kind of similar to, let's say a third-party consulting arrangement that the folks on the call might be familiar with, an H1B petitioner kind of assigning a foreign national to work at an end client site. If the end location is a qualifying cap exempt organization, such as a non-profit hospital or university, let's say, that meets the criteria and meeting that definition, that individual is also, I suppose that petition is also considered cap exempt, even though the sponsoring employer is not cap exempt per se. So I suppose that's a change that took effect, 3 years back, and it remains in effect today. Okay, so we'll talk about H1b concurrent employment. There is the opportunity to file a concurrent H1b I-129 petition, by a sponsoring employer that is subject to the cap, so long as the beneficiary is working at a cap exempt, petition an employer as well. I suppose some pointers, to bear in mind, as you can see from the information here on the slide, is that there is no minimum number of hours per week that a beneficiary must be employed by the cap exempt employer in order to qualify for cap exemption based upon concurrent employment. However, obviously the best practice is that the use of this strategy of concurrent employment works best when the intended length of the cap exempt and the cap subject employment is around the same amount. So I suppose if someone is working just a couple hours at a cap exempt entity sponsored by that organization, the most of his or her time at the cap subject employer, based upon the terms of that cap subject petition, that might raise a red flag. So afterwards, we talked about the different alternative options for an individual who might not have been selected in the CAP lottery. So a look at the skilled worker rule that I referenced earlier. I mean, the full name of the skilled worker rule is called the Retention of EB1, EB2, and EB3 Immigrant Workers and Program Improvements Affecting High-Skilled Non-Immigrant Workers. So that's a mouthful, to say the least. So we're just going to shorten that to to say the skilled worker rule. And I mean, this skilled worker rule, I mean, it's pretty much the long-awaited, regulatory authority for the AC-21 statute that was passed, I suppose 20 years ago. Just a discussion on the grace periods involved. There are two applicable grace periods: the 10-day one and the 30-day. The 10-day one, the 60-day one. So the 60-day grace period was introduced based upon early separation with a sponsoring petitioning employer to allow the foreign national worker to seek a sponsorship by a different employer and transfer his or her H1b to that other entity, perhaps make departures to leave the U.S. based upon the termination, or perhaps seek a change of status to a different visa category that the foreign national might be eligible for. I mean, there was also, a discussion point on the 10-day rule as well, and how that, was now expressly extended to other visa categories, because as some might know, originally the 10-day rule was, it just talked about H1b O and P visas. So there was no reference to Ls or anything of that sort, or E visa category. I mean, it was kind of understood that, those other visa categories kind of, fell under the umbrella of the 10-day grace period. As well, as folks know, individual who is outside the U.S., they can come into the U.S. 10 days before the start of the validity period on the approval notice, and then 10 days after to kind of wrap up their affairs and depart the country upon the expiration of the validity period. But interestingly, the skilled worker rule here from 2017, and it expressly extended that to the other visa categories. So the next, little topic to talk about under, this particular session was, discussing portability. I suppose since a lot of our clients, foreign nationals and the sponsoring companies, they file H1Bs, everyone is familiar with portability and the ability to have the foreign national start based upon the filing of a transfer petition. So I mean, there is some, mid-level and some, complex concepts discussed pertaining to this topic as well. And probably, the point of discussion to get into the most is for bridge petitions. So importantly, if a preceding petition, H1b petition, in a successive H1b portability filing requesting an amendment or extension of stay is denied, then all subsequent petitions become unapprovable unless the beneficiary's previous approved H1b status remains valid. So I suppose that just a way of saying that we have to maintain that bridge. I mean, it's called this concept is called the bridge petition. As a result of that any kind of severing of that bridge, it does impact the ability for that individual to continue to maintain status moving forward, provided that the I-94 for that individual has not expired. And then lastly, for this session, something to bear in mind is that for I-9 purposes, the 240-day rule does not apply. When it comes to a change of employer or an amendment petition filing based upon portability. Everyone is familiar with the 240-day rule, how it grants continued stay in the U.S. and work authorization for the recipient of an extension filing, and that that pertains to other visa categories, not just limited to the H1B. But I suppose portability kind of trumps that, where if a petition if a successive H1B petition filed by a different employer for a transfer of the individual remains pending beyond 240 days, well, work authorization still attaches during that period of authorized stay for the foreign national worker. So I suppose that's a unique attribute of this, where work authorization is actually lengthier than the typical continuation of previous approved H1B employment that folks are familiar with pertaining to the 240-day rule. Okay, so in the interest of time, we'll go to the second half of today's presentation, some of the higher level, more complex issues. So we only have 10 minutes, unfortunately. But just really breezing through this, I suppose the one thing that I wanted to bring to your attention is the reduction of hours. Someone goes from full-time to part-time, an amendment petition should really be considered to be filed for that H1B worker. For an H1B, from a compliance standpoint, removing the fact that, of course, we want to make sure that the employee being sponsored maintains his or her status, but removing that, from a compliance standpoint, the critical thing is the LCA and the attestations involving the LCA. The LCA is basically concerned about wages and working conditions, to protect U.S. workers. It really has no skin in the game for work hours. I do think maybe there's maybe you do check off full-time or part-time. Maybe that is part of the form. But when it comes to enforcement, as long as the H1B beneficiary is being paid the required wage, you can define that as the higher of the actual wage or the prevailing wage. The actual wage is what workers at that employer are being paid, including foreign nationals, including U.S. workers. So if company XYZ pays its software engineers $90,000, and that's just standard, that's the actual wage. If if the prevailing wage for that occupation in the intended area of employment is $85,000, well, the required wage is $90,000. You can't go below the actual wage. So that should be the wage that the beneficiary, the foreign national, should be paid. So let's say that a foreign national is being paid $120,000 because that's the actual wage. That's what other software engineers at an H1B employer are being paid at, and the prevailing wage is $90,000. And because of COVID, the company had to scale down their pay, where everyone was reduced $20,000. So now everyone's being paid $100,000. And as part of that, because they're not paying as much, everyone's hours are reduced, where people are not technically working full time. But as long as someone is being paid the required wage, the higher the actual or prevailing wage, from the Labor Department's standpoint, there really is nothing to investigate. The requirements for the public access file, the LCA, and the DOL attestations that are contained in every ETA 9035 form are met. So, they don't care that if someone is working 30 hours a week as opposed to, 37.5, let's say, for full time. Now, is this an issue for the foreign national maintaining his or her status? The I-129 was filed for full-time employment. It's there on page 5 of the 129 form, 40 hours a week. If they're reduced to 30 hours a week, is that a failure to maintain status? And it seems like the consensus is that, it depends. There really is no firm, bright line yes or no that's going to be an issue. The worst thing to do is to treat U.S. workers differently than foreign nationals, meaning that, the thing that a company should not do is furlough U.S. workers and keep foreign workers at on payroll and continue to have them work full time. U.S. workers should not be reduced to part time while H1B employees are kept at full time. that's a discrimination, action just, waiting to be filed. Any kind of suit in court for, a employment discrimination, a conduct on the part of a company, I mean, those consequences are just so much more severe than any kind of Labor Department violation at DOL for an LCA issue. So, I suppose it kind of came from that, that sphere and that realm that, what's the best way for employers to mitigate, their damages, their, lack of compliance, et cetera. And perhaps, knowing that a reduction of hours from full-time to part-time, it might not necessarily result in the employer needing to file an amendment. But I suppose one thing to exercise care is I mean, obviously ICE has relaxed the physical in-presence, requirement for inspecting I-9 documentation for identity and employment eligibility for a new hire. So, that can happen virtually, and, they've extended that deadline. But, the one thing to bear in mind is that, eventually your employers need to go back and, have those inspected in real time, in person, once this pandemic concludes. But, how is that even possible? We had that instruction from ICE, but employers, there's no implementation method in order to do that. It's not realistic for a company that has 20,000 employees where, a whistle blows and all 20,000 employees come back to the office. Everything's going to happen in staggered stages. So, how is an HR manager or, someone responsible for this able to track that within 3 business days after this employee came in, I inspected their I-9 documentation in person? Well, if 50 employees are arriving, on a Monday and 100 employees are arriving on a Thursday, I mean, is all of that going to be just manually tracked? That's not going to be possible for a company that size. This provision into the handbook saying that the company, is aware of these accommodations that ICE has, provided in terms of virtual, I-9 inspection, and the company is going to inspect them in person within 3 business days, so that at least something is in writing, so that if an I-9 audit were to happen, an investigation by ICE later on, 5 years down the road, and the employer has to produce, this I-9, there's nothing on the record if the employee handbook is not updated where the employer can say, yes, I complied with the rules and I inspected this, within 3 days after this employee returned back to the office. If the employee handbook is not updated and the employer manual, then there's nothing to produce to ICE. So I suppose that's a critical thing to keep in mind moving forward. That comes to the conclusion of our time, and hope everyone has a good rest of the day. Thank you.